Our freedom of conscience and religion is being challenged by laws and regulations imposed by secular society. It's time to hear from the top Christian litigators in the nation who have come forward to tell us the truth and help us defend our faith.
Hear ye, hear ye. All rise. Faith on Trial with Defender of the Faith, Deacon Mike Mano, is in session.
A good Thursday morning. I'm Deacon Mike Mano, and this is Faith on Trial. I'm here with Gina Knoll. Gina, how are you?
I'm well. How about this hot weather? Ready for the state fair, aren't we?
Yeah, we're getting ready for it not too long from now. Today we've got an interesting topic. We're going to be talking about some new administrative rules that are being proposed for our schools and things like that involving transgender students. And we're going to talk to our expert from the Heritage Foundation, Sarah Perry. And the saving grace right now in this whole thing is the Tennessee court has blocked the enforcement of that rule until the whole matter can be heard in court. So.
Well, and I couldn't help but, we've discussed the West Virginia versus the EPA case where the administrative division had overstepped its bounds in making rules that were well beyond the legislation it was intended to support. And I'm anxious to find out if the Department of Education has done the exact same thing in this case.
I think that's what's going to happen, but we'll have Sarah here in a few minutes to tell us all about it.
Explain
what's going on.
Yeah.
That's right, yeah.
That'll be good.
Do you have a prayer to open us up with?
Oh, sure. Of course. Always a prayer for peace in the name of the Father and the Son and the Holy Spirit. God of peace, bring your peace to our violent world. Peace in the hearts of all men and women, and peace among the nations of this earth. Turn to your way of love those whose hearts and minds are consumed with hatred. Strengthen us in hope, and give us the wisdom and courage to work tirelessly for a world where true peace and love reign among the nations and in the hearts of all. Amen.
Amen. Thank you very much. And we will be back shortly with Sarah Perry from the Heritage Foundation to talk about these new administrative rules that are being proposed by the Biden administration. You're listening to Faith on Trial on Iowa Catholic Radio.
Support for Iowa Catholic Radio is provided by Ashworth Vision Clinic. Complete eye exams, contact lenses, glasses, glaucoma testing, and pre- and post-operative care. 515-440-4610. AshworthVision.com.
Iowa Catholic Radio would like to thank our business partner, Elite Glass and Metal, LLC in Johnston. New construction, existing projects, and emergency service. EliteGlassandMetal.com. 515-284-0141.
Support for Iowa Catholic Radio provided by Paul Martin and Paul Mitchell, owners of Imogene Ingredients. Imogene Ingredients supply specialized feed ingredients for livestock and pet diets to improve maternal and young animal health in both conventional and organic production. And we're back. You're listening to Faith on Trial on Iowa Catholic Radio. And we have our friend Sarah Perry from the Heritage Foundation with us. She's a legal fellow with the Meese Institute for Legal and Judicial Studies. And she's written an interesting article and is following a case that we are interested in. And that's a proposed set of rules by the Biden administration that would cover all sorts of things like transgender rights and everything in schools. And Sarah, why don't you give us the background for this now?
Well, this is a huge development coming out of the Biden administration. This involves Title IX of the Education Amendments of 1972. Very short statute, but what it prevents is any discrimination based on sex in any federally funded education program. Now, that's any dollar that comes into any school, public or private, K through 12 and secondary. So we're talking a number of universities, a number of K through 12 schools in the United States. Most schools accept some sort of public funding, either directly or indirectly. So I want to start by identifying exactly how broad the application of this is going to be, but it does a couple of things, the most problematic of which, and right at the top of everybody's mind, is to expand the definition of sex in Title IX to include gender identity. Now, what does that do? Well, Title IX envisions the separation of different facilities for men and women and boys and girls. Remember that it was passed in 1972 because of the women's liberation movement. It was as a result of the effort for feminists after they were working to get equal pay and they were getting protections in employment to also get those same protections in education. But where we are now is that piece of essentially feminist legislation requiring equality between men and women in education is now being used as a sword to attack biological women, because what it does is it opens up every sex-segregated facility, platform, or admissions program for women. So we're talking bathrooms, locker rooms, dorm rooms, housing accommodations, and yes, even sports teams. So it is a catastrophic change and something that the Biden administration has worked very long for since he was sworn into office. So they have just released their proposed new rule, and it's going to be open for public comment until September 12th, when they have to make this rule formal for the rest of the country.
Now, I think this may even go back beyond the Biden administration. I think a lot of this goes back to the Obama administration. There was a letter, a Dear Colleague letter, that was sent out by both the Department of Education and the Justice Department that went to all the school administrators that was suggesting this or indicating that this is be the way that they would enforce the Title IX. And I do know that Congress on several occasions has taken up the idea of expanding the word sex in the Title IX law to include sexual orientation, but those have always been rejected. So I think that's kind of the background here that we're looking at, which makes it look pretty bleak.
Correct. And remember that before he left office, President Obama issued what's called informal guidance, meaning a letter that came from his Secretary for Civil Rights, basically opening up all bathrooms and education programming to individuals based on gender identity, not just sex. But because that was informal guidance, nothing more than a letter, and that was a favorite of his Secretary for Civil Rights, Catherine Lehman, who ironically is once again the Secretary of Civil Rights under Biden. We flipped it when we were in the Trump administration, and when I was at the Office for Civil Rights at Department of Education, we rescinded it immediately, determining that sex means biological sex, taking that informal guidance away. Well, along came a case from the Supreme Court called Bostock versus Clayton County. That muddied the waters a little bit, and in that case, the Supreme Court determined that in the context of employment under a different statute, a statute called Title VII, that there could be no discrimination based on sex, but also based on gender identity and sexual orientation, because you couldn't take sex into account without taking the other into account. Well, Title VII and Title IX are worded differently. They came out at different times, and they have different purposes and in different congressional histories. So it was very clear to us that Bostock did not apply to Title IX. And if you remember from that decision, Justice Gorsuch, writing for the majority, said, we're not taking into account any other anti-sex discrimination laws.
Right, I thought he was very emphatic about that, too.
Very
Yes.
emphatic, very emphatic. Just Title VII and employment, the rest of those cases are not before us. Well, the Biden administration doesn't seem to have read that part, because they took that opinion of Bostock and they ran with it. And one of his first executive orders in office as a newly minted president was to issue an executive order expanding sex in all federal law to include gender identity. So we've seen this trickle-down effect in the Department of Justice, Health and Human Services, Department of Education, the EEOC, you name it, it's been expanded. Well, of course, for my part, as the mother of 3 teenagers who are in school, I am distinctly concerned with Title IX and how that's going to impact the education for my 3 children and the safety in particular of my teenage daughter.
Yeah. Now, I also understand that as this is supposed to apply, it applies to any facility that's receiving federal funds, no matter how small an amount.
That's absolutely correct. In fact, if you take as a administrator of a school, a student on a reduced lunch program, that's part of a government benefit that is sufficient to subject you to Title IX. The law says directly or indirectly. So you could offer someone a scholarship or a Pell Grant so that they're able to attend your university. That still subjects you to Title IX, even if you don't take any other federal funding.
Sounds like a Catholic elementary school that accepted funding for lunches would be covered now. Okay. Gina?
The Iowa legislature recently passed legislation signed by the governor that clearly defines women's sports in Iowa at the high school and elementary level. How would this ruling affect this state legislation?
So it's very interesting you should bring that up, because just yesterday, the U.S. District Court for the Eastern District of Tennessee, Judge Ashley, determined that the Title IX rulemaking, in addition to the rulemaking for the EEOC and the rulemaking for the Department of Justice, all of which expanded sex to include gender identity, was essentially outside the bounds of the federal government's authority, that it was, in fact, illegal. And it ruled for the plaintiffs, which was a group of 20 states, all of whom had passed laws doing very much like what the Iowa legislature had just done, defining sex to be biological sex alone, as we've always understood it under the law. Remember, we're tasked with the plain, ordinary meaning of words like this. We shouldn't have to dissect into a million different pieces whether or not sex means gender identity, because we know in 1972, the ordinary and plain meaning of the term sex was biological distinctions between men and women, males and females. So now that Iowa has a rule like this, now that the legislature has just passed a bill like this, they actually joined the good company of 20 other states who have passed similar laws, and on which the federal district court in Tennessee has just determined, listen, these states can't comply with federal directives because they have their own laws defining sex to be biological. And so because of that, you've made it impossible for them to actually acquiesce to these determinations. So we find the rulemaking from the federal government to be illegal. Now, we understand, we anticipate that the federal government will naturally appeal such a determination. This has been something very important to the Biden administration from the outset of the administration. Obviously, gender identity is something this president talks a great deal about, but we're incredibly pleased that this federal judge has really taken a very bold, brave move and has determined that these plaintiffs, these 20 states, are going to be granted relief until this particular decision is appealed by the Biden administration. Where we think this will go, I think in the end, this is a battle that is ultimately destined for the Supreme Court. They opened the door to this kind of litigation, and unfortunately, I think that's how long it's going to take.
So, Sarah, speaking of the Supreme Court, just ruled that in the case of West Virginia versus the EPA, ruled that the administrative agency overstepped its bounds by going much further than the legislative intent of the laws that they had written rules for. Will that be some sort of precedent for this particular case?
Yes, we were extremely gratified by the outcome in West Virginia versus EPA, because what this did was essentially pin back the ears of the Biden administration that's been using different federal agencies to expand its authority under federal law. You cannot substitute agency rulemaking for essentially creating a new requirement. What rulemaking is supposed to do, and for those who are not sort of up to their eyeballs and things like this in Washington like I am, rulemaking is essentially an opportunity for a federal agency to clarify the requirements under federal law, not to make new law, but to clarify potentially ambiguous law. And what the Biden administration tried to do in the EPA case is use the Clean Water and Air Act to basically say, we're going to infuse a giant climate change policy on every carbon emissions creator in the country to the tune of hundreds of thousands of dollars. And the Supreme Court said, whoa, there was no intent to do that when that statute was passed. You guys have essentially plucked this out of thin air. Because of that, we're hopeful that when Title IX takes what we believe is going to be a similar route, that, again, the Supreme Court will say you've outstepped your boundaries here.
That's what I thought. Well, that's good
that's what
for
we're
us.
hoping for anyway, yeah.
Right,
now,
to protect our women.
Obviously, with the decision on Roe, where things are being turned back to the states, do you think any of this stuff will be bifurcated, where the states can do one thing, or each of the states can do one thing, and federal government can step in where there's a void only?
You know, we're looking at kind of a showdown here of epic proportions when it comes to federal rulemaking versus state law. Do federal rules, interpretations of federal law, not actual federal laws, but interpretations thereof, have more power than a democratically enacted proper state law? And this is where we're going to, I think, eventually see this discussion transpire at the Supreme Court. Once we've got this sort of showdown, we, for example, are looking at, among other things, whether or not the FDA's regulatory authority of abortifacients like RU-486, mifepristone, whether or not their approval for being safe and effective for use is actually more important if it preempts a state's regulation on abortifacients at the state level, their restriction on the state level. That is something the heritage legal scholars are currently researching. They're determining, can, for example, the federal government protect interstate travel if, for example, a state would like to restrict travel for certain purposes. We know there's a constitutional right to interstate travel, but a state also has a right to legislate and lawmake on interests that it feels is tantamount to health, safety, and welfare, like the health and safety of unborn children. So we're going to see, I think, a showdown of what the federal government's regulatory authority looks like in comparison to the state lawmaking authority. And where that will ultimately shake out remains to be seen. But I think I'm encouraged based on what we saw with the CDC eviction moratorium being struck down during COVID, the OSHA federal vaccine mandate being struck down by the Supreme Court during COVID, and now the EPA Clean Air and Water Climate Change Authority being struck down by the Supreme Court. I'm hopeful that when it comes down to it and the Supreme Court is ultimately faced with these questions, it will reinforce the fact that our nation, as a constitutional republic, has to have an appreciation of and protection for the importance of states' rights.
That's right. And now it seems to me that in the past, courts have been very deferential to decisions that are made by the administrative agencies that are interpreting the laws that there are I guess that they're taking care of. They're tasked with expanding, or not, I shouldn't say expanding, but regulating, and that the courts gave a lot of deference to these administrators. Now, do you see that changing now in light of some of these cases where there has been that overstepping of authority?
You know, it's interesting because what we're seeing is some individuals, some scholars questioning whether or not Chevron deference, which is the deference of the shorthand legal version of what we've seen in the past and what the Supreme Court has held to, might actually be on the chopping block. You know, this is a bold term for the Supreme Court, not just an overturning Roe versus Wade, but really for all intents and purposes, throwing out the Lemon v. Kurtzman Establishment Clause test as well. So this court has demonstrated boldness in eventually coming around to the position of saying, listen, these weren't great rules to begin with, and they've actually just complicated lawmaking authority in the United States. I think the next one could be the Chevron deference doctrine, in which the federal courts have given a ton of leeway to federal agencies to make these interpretive rules and given them more weight than what states have been able to do in the past. They've seen the misuse of that under this administration, and I think the Biden administration can blame themselves for forcing the Supreme Court to a point where they are now possibly reconsidering Chevron deference and might say, you know what, in a showdown between federal agencies and state lawmaking bodies, we're going to find on the side of the state lawmaking bodies.
Seems to me that they're going back to what we'd call black letter law.
Absolutely. And that's something encouraging, I think,
Yes.
not just for originalism and for the court system, but also for individuals of states like Iowa, where lawmakers say, listen, we're going to step up. We're going to protect the sanctity of life. We're going to protect the biological reality of women and girls because we want to legislate on these issues at the level closest to us.
Well, we're going to keep up on all this stuff, and we're happy that you're doing it for us, too. And we certainly are going to have you back to talk more about these things, because it seems to me with this court there's going to be a lot of them that are going to pop up.
Definitely. And thanks so much for having me.
Oh, certainly.
Thank
we
you,
appreciate
sir.
your time and everything. Thank you so much for joining us, and God bless you and your work and the Heritage Foundation. Thank you. You're listening to Faith on Trial on Iowa Catholic Radio. We will be right back after our message.
Support for Iowa Catholic Radio provided by Mercy College of Health Sciences, where you can chart your course for more.
Mercy College provides unparalleled clinical rotations, hands-on learning, accelerated education, and flexible schedules. Since 1899, Mercy College has been transforming students into healthcare professionals. Guided by Catholic values, our faculty put classroom theory into practice. Students are prepared for roles in service and leadership throughout their own careers.
Learn more at mchs.edu. Mercy College of Health Sciences, mchs.edu.
Support for Iowa Catholic Radio provided by Five Sons Naturescapes. Five Sons Naturescapes is a Catholic veteran-owned family company providing premium outdoor landscaping. Learn more about Five Sons Naturescapes at fivesonsnaturescapes.com. fivesonsnaturescapes.com.
Support for Iowa Catholic Radio is provided by CTO. What great news for donors to the Catholic Tuition Organization. You now receive 75% of your donation back in Iowa tax credits. Your support has helped thousands of students attend our Catholic schools. Best gift ever. Online, ctoiowa.org. At CTO, the bottom line, it's for the kids and their future.
And we're back. You're listening to Faith on Trial on Iowa Catholic Radio. Gina, very interesting program today,
Okay.
and it's something that we should be taking more notice of, these things that are going on.
Absolutely. And from the standpoint of Sarah's explanation of this rulemaking, which is over 700 pages long, I thought she did a brilliant job of helping me, a non-lawyer, understand how this affects our everyday life.
Well, there is a federal rule, federal administrative rules that articulate on how these administrative agencies adopt their rules and the different types of
There's a
ways
process,
they can use.
right.
There's a process. And what the courts are saying in some of these cases now is that the administrative agencies have well overstepped their bounds. Now, one of the things we didn't get into is what is going on now is just a blatant attack against women, I think, because this will affect all the sports programs, right? If you can't discriminate on the basis of sex, that means your daughters are going to be running track against biological men. They're going to be in the same locker rooms with them. When the band takes a trip on the road to go someplace, you can't segregate the sleeping quarters from one another. What protection is there left for women? This Title IX was supposed to be a big godsend for women, especially women in sports. And it was.
Title IX has been successful in lifting women to higher positions in education and all kinds of activities.
It's opened them up to being able to get more scholarships, both athletic and academic scholarships. And I think we're just going backwards with this. And I have to wonder why. why such a push for all these transgender rights at the disadvantage or on the disadvantage of the young girls and women who want to compete in these sports?
Well, I have to feel that somehow, I haven't figured that out yet, but there's money involved.
Probably so.
Somewhere
Probably
in
so.
all of it.
A lot of woke people have a lot of money, and they spend it liberally. Yeah.
Right.
Yeah.
And it builds fear. I mean, fear feeds power, and I think we've seen that quite a bit in the last couple of years.
All right. Well, let's end. Oh, you have something about the concert.
Oh, yeah, Iowa Catholic Radio this Sunday evening. Go to the website, iowacatholicradio.org, and buy your tickets. Oh, I'm sorry, .com. It's iowacatholicradio.com. It's bookmarked on my browser. They have the concert with country music star Scotty McCreery. So it's at the Iowa Events Center Ballroom downtown.
You still get tickets and everything?
I have 4 tickets, and there's some VIP options to get even closer to the artist. So check it out.
Very good. Very good. We certainly appreciate that notice. Let's end now with our Defender's Prayer, which we need, as you can hear from
absolutely.
Yes. St. Michael the Archangel, defend us in battle. Be our protection against the wickedness and snares of the devil. May God rebuke him, we humbly pray. And do thou, Prince of the heavenly host, by the power of God, thrust into hell Satan and all those evil spirits who roam about the world, seeking the ruin of souls. Amen. Thank you for listening. We will be back again next Thursday for another edition of Faith on Trial. Until then, have a blessed and peaceful week.
Our freedom of conscience and religion is being challenged by laws and regulations imposed by secular society. Faith on Trial, with Defender of the Faith, Deacon Mike Mano. Faith on Trial, Thursdays at 10 a.m. on Iowa Catholic Radio, iowacatholicradio.com, and the Iowa Catholic Radio app.